Molupe, good afternoon and welcome. Senate, welcome everybody. We're all welcome to the 17th day of our 12 weeks legislative drafting course. Today's topic is stages of the lawmaking/legislative process. It is a continuation of yesterday's lecture. It is very important for a legislative drafting lawyer to know all these steps within the lawmaking process, because failure to comply with any of these steps could nullify the legislation that is finally a product of the lawmaking process. Now, this is based on the judgment of the Supreme Court. We looked at it yesterday in the case of Attorney General of Bendel State against Attorney General of Federation, 1981. This afternoon, we have in our midst our erudite professor, in the person of Professor Tony Clinton Jaja. Okay, please, gentlemen, if you were here yesterday, you'll recall that we started discussion on the lawmaking process. So, can we go over it again? Who can remind us what we discussed? Just anybody, if you were here yesterday, and you remember anything we discussed. Hannah, you have the floor.
So yesterday, okay, am I audible, please? Can anyone hear me?
You just have to increase your voice a little more.
Oh, okay, all right.
Madam Mutu, please, after Hannah, you take the floor.
Okay. Good afternoon, everyone. Good afternoon, Prof. Yeah, it's good to be here today. So, yesterday we learned about the legislative process. Then, from yesterday, from the notes I took, we learned about firstly the origination of the bill, that the bill could emanate from or a private member bill, or it could be a bill originating from the judiciary. So that's how bills are originated. Then the first stage is usually how the bill originated, and the second stage is the initial review, where the bill will be reviewed, by
Anna, we've lost you.
The bill conforms with the requirement, goes to public notification. Oh, okay. I think my network is...
No, go ahead. Continue. You're back.
But am I audible?
Your network was fluctuating.
Okay.
Continue, please. Okay, while we wait for Hannah to sort her network, Hannah, thank you for your attempt. Madam Muju, can you make your contribution in less than 2 minutes? Thank you.
Sorry, sir, I didn't attend yesterday's class.
Okay.
So sorry about that.
No problem.
Thank you.
Okay, who was here yesterday? Who else? Who else can try?
My internet is out.
Okay, Honorable, you may proceed, sir.
Thank you, Prof. and other colleagues. Like the woman that was talking, a bill can be initiated from the executive wing of the government, from the judiciary wing of the government, and of course members of the parliament, that is from the parliament itself. And of course, when that is done and is acknowledged at the level of the House, the one of executive is actually forwarded by a memo or a letter from the executive wing. Of course, extended to that of judiciary is also by that. But that of the House a member, if somebody is a member of the National Assembly, either a parliament in the House of Reps or in the National Assembly, that of course will be forwarded to the Speaker. Then, of course, like you said yesterday, there is usually a directorate at the level of the Assembly, the National Assembly, to first scrutinize the bill, whether it's in conflict with the Constitution or is in conflict with another law. And where that is not in conflict, of course, is now placed before the Parliament for the first reading. And of course, if the first reading is done, it is actually the responsibility of the clerk of that house to read it for the first, at the level of the first reading. And of course, it will come up for second reading. At the level of the second reading, like we said yesterday, the person who initiated the bill on the floor will have to justify. That is the period of justification of that bill, where you have to present logical arguments in support of that bill. And if it is taken by the House, that is one.
Please, sir, what is that argument called? Because we need our terminologies.
The argument in justification of the bill, Abi?
Yes, sir. Yes, sir.
I'm not able to recall. Just the second reading, the debate, Abi?
Your lead debate or a brief of argument.
Yes, your lead debate. In justification of the bill. That's the lead debate. Of course, other debates will also have to happen at the level of the floor, those in support and those in favor. Like Prof said yesterday, perhaps one third of the people in this section of that Parliament will have to support it to go for the second reading. If it goes for second reading, that's at the committee level. We have to go for public hearing and stuff, like you mentioned yesterday. I think that's just a little contribution.
Thank you very much. That is a very fair attempt. Thank you, sir. There's another hand up. Okay, his hand, she has put down her hand. Can we have one last person? One last person. I want somebody from Lesotho to speak. Madam Caroline, are you attempting to speak? Bletobo, not you. I will need another person. Senate, you were in class yesterday, right? Imelo, you were in class yesterday.
Yes, Ebenezer, I was in class. Please repeat the question, my leader.
Awesome. So we are saying, can you tell us what you learned from yesterday's class? Any of the processes, anywhere you remember what you got from yesterday's class in the lawmaking process?
Thank you very much, Ebenezer, and good afternoon, everyone. The real essence of legitimacy for a process of creating legislation should be the fact that it has adhered to all the steps that have been earmarked as processes or procedures that have to be complied with. Again, we learned that one of the key issues that as legislative drafters we should look at is the fact that all our bills have to walk these steps categorically, and we must not actually allow any other step to not be included within the process of legislative making. We also learned that when a bill is first presented, the one who is sponsoring the bill has to provide to how he or she wants this bill to be adopted. What are the reasons that compel him or her to advise the House to adopt the bill? So that argument sets the tone for how the bill will be perceived in the House, and also the considerations that the plenary should look at. And if I recall well, the plenary should be the full House when it has gathered to consider a bill. We will call it the plenary. Again, we also looked at the technical consideration that because legislative drafting is a specific sector of the law, it has its own terms, and as drafters we should take note that when you refer to the parts of a bill that has not been yet considered before the House, you will be referring to it as clauses of the bill. But when we are now talking an act, we will now be talking about sections. We learned also that the process of making the bill requires that the House, when looking at the bill as a plenary, should have every single clause of the bill read and adopted. If there are any corrections that have to be done, then such should be noted, so that when the clerk of the National Assembly looks at the final deliberations, he is able to now come up with what we call the clean bill, which will be every single item that was ever raised in this deliberation. And then once those amendments have been discussed and approved by the plenary, then the clean bill will come out as the final product of all the considerations that everybody has given during the process of interrogating the bill and its rightfulness to become law. Thank you very much, Ebenezer. That's how far I had.
Thank you very much. You almost captured everything, but for the technicality of the language, we say clerk of the House of Representatives, clerk of the Senate, clerk to the National Assembly. Now, there are three offices. For the Senate, the clerk of the Senate works for the Senate. The clerk of the House of Representatives works for the clerk of clerk to the National Assembly is a separate office. Now, Mr. Kingsley, quickly, yours, so that it won't seem I shut you out. Kingsley Wakwe, please.
Okay, thank you very much, sir.
Thank you, my brother.
Yes, although I didn't join the class from the beginning, but from where I joined, we were talking about the clean copy. That is, after the third reading, a clean copy is produced where House members had to agree on the bill. That is the concurrence. After which is taken to the clerk who takes it to the president for assent, and it's always in 3 copies on a vellum paper.
Yes.
Now, the 3 copies, after the assent of the president, a copy is taken to the Attorney General for gazetting, a copy is taken to the CJN for enrollment, while the 3rd copy is taken to the clerk to the National Assembly for numbering. Now, you distinguished, okay, I rather ask a question where Prof. Distinguished the difference between the clerk to the National Assembly and clerk of the Senate, as well as clerk of the House of Representatives, which you are just trying to explain now. That the clerk to the National Assembly is a separate office of its own, who supersedes every other clerk. Unlike the clerk of the Senate, which is just for the Senate, and clerk of the House of Representatives, which is just for the House of Reps. But clerk to the National Assembly is for the National Assembly generally, both the House of Reps and the Senate. I think that's the little comment I have to make, sir.
Thank you very much. That was a good one. Okay, by way of revision for today and for benefit of those who were not here yesterday, if you check the WhatsApp platform, we posted a diagram there, would I call it that has 11 stages of lawmaking processes. Look it up. The stage 1 is origination of the bill, bringing the bill into existence. The draftsman has finished drafting, or the draft person has finished drafting, and submitted the bill to his principal. Let's assume it is a private member bill. An honorable member or a senator engaged you to draft. You have drafted, and you have submitted your bill to your principal. Or it could be an executive bill. The Minister of Justice has drafted, and the president has done a cover letter to the National Assembly, to the Senate President, of course, you told us yesterday that it is the majority leader of the ruling party that takes up the sponsorship of an executive bill or a bill emanating from the judiciary, whereas private members will sponsor their own bill. So if the majority leader can sponsor a bill in his personal capacity, at that time he does not require any cover letter. But if the bill is emanating from the legislature, from the executive or from the judiciary, the executive, the president, writes a cover letter stating that they have this bill before the National Assembly, before the Senate or before the House of Reps. Then the majority leader takes it up from there. So the person has submitted the bill. The bill has been initiated. Now, remember also that we mentioned that the bills have serial numbers. And the serial number starts with, if it is a Senate bill, it will be numbered with SB, Senate bill, then the serial number of the bill. If it is a bill for the House of Reps, it will start with the initial HB, House bill, then the serial number. That is the initiation of the bill, origination of the bill. Then stage 2 is now initial review. Where is this bill submitted to? You don't just dump it anywhere. So the Rules and Business Committee of the National Assembly, part of their responsibility is to draw up an agenda of the day-to-day happenings on the legislative business or on a legislative business day. So what's going to happen today at the sitting? The agenda for that day, we call it order paper. The activities of the House for the day. So these people, this committee whose responsibility is to bring about, to cater for the rules and business of the House, they will go through that bill. That's the meaning of that initial review. This is stage 2. What are they reviewing? Did the bill comply with the format, with the in-house drafting style for the National Assembly? For example, at the National Assembly, interpretation clause is usually at the end of the bill. The interpretation clause. For Lagos State, if it's a technical bill, their interpretation clause is part of your preliminary provisions, because they believe you should acquaint yourself with the definitions of terms and all that before getting into the body of the bill. What you rush to the interpretation, check the meaning, come back. Now, if you bring a bill having the interpretation session in the preliminary part of the bill, they will put your bill aside. It will not be okay for hearing. So that's part of what they are doing here. Check whether this bill is properly numbered. Check whether it conforms with their in-house drafting style. Then assign a date for the first hearing to that bill. Stage 3 is that the public is notified. Okay, there is a bill before the National Assembly for the establishment of a national university for fishing and agriculture. Now, the public is aware. The date that has been assigned by the Rules and Business Committee, on that date, the first reading happens. Now, what happens at the first reading? The clerk, if it is the Senate, the clerk of the Senate, if it's the House, the clerk of the House of Assembly, reads out to the hearing of every member present the short title of the bill and presents it before the Speaker, if it is for the House of Reps, or before the Senate President, if it's the Senate. And that is all there is to the first reading. Then another date is given for the second reading. By this, between the first reading, in fact, from the first reading, every member, that bill has already been circulated by the person sponsoring it. By the sponsor of that bill, they have circulated it. At the second reading is where the sponsor of the bill does his lead debate, presents his lead debate or brief of argument. Now, that lead debate contains his points, his arguments in favor of the bill. Now, also understand that if that bill seeks to establish a government agency, as you are submitting that bill, attached to that bill will be another document. What's the name of that document, if you remember? We have mentioned it repeatedly here.
Financial estimates.
Sir?
Financial estimates.
Yeah, compendium of financial estimates. Now, if that bill seeks to establish a government agency, you attach to it a compendium of financial estimates, which is 1 year budget of what it will cost the government to establish that agency. The purpose of that is this: one, for the senators to do a cost-benefit analysis. Is it a worthy venture for the federal government to spend this type of money to establish this agency? One. Two, must this agency be established? Will it not be a duplication of an already existing agency or a similar agency? Can we amend the existing law to bring in this agency into it, incorporate what this bill is proposing into it? The example I usually give, there's a bill that seeks to establish Peace Corps. We already have civil defense. We have civil defense. So Peace Corps, from the surface view, might be playing a similar role. So somebody might say, instead of that, can't we amend the Civil Defense Establishment Act? Can't we just have civil defense employ more people? Can't we incorporate whatever role these people want to do? Can't we expand the scope or the jurisdiction of what civil defense covers and incorporate this? Another person might counter that argument and say, no, there will be need for us to have proper distinction between the role of civil defense and what Peace Corps will do. So, still on that stage 5 now, because we are talking about second reading. As you have accompanied your bill with compendium of financial estimates, you present your lead debate, marshal out your argument point by point. Then, if there are persons who have a contrary view to your bill, they will rise and present their own debate in opposition to your bill. If the other persons who are in support of your bill, they will also present their debate in support of your bill. At the end of the day, the presiding officer, usually the speaker or the Senate president, as the case may be, will put the House to a vote. Here we use voice votes. Those in favor of this bill say aye. We always hear it all the time. Those against say nay. Or those in favor of this motion say aye. Those against say nay. The ayes have it. The bill passes second reading. But if the ayes do not have it, that's the end of the lifespan of that bill. And I said yesterday, technically, we say that the bill does what? Who can remind me? If the bill does not pass the second reading, what do we say? We say that the bill is negatived. The bill has been negatived. So it ends there. But if the bill passes second reading, we proceed to the next stage, which is committee stage. Is Mr. Emmanuel here yet? Not yet. Because he asked a question about the difference between the committee, the first one and the second one. At this stage, I did tell us yesterday that bills revolve around different subject matters. and the House has different committees relating or overseeing different areas. So, assuming the bill is on transportation, maybe air transport, you now refer the bill to the committee, House Committee on Aviation, because it has to do with their area. If the bill is on security, you refer the bill to the Committee on Security. If the bill is on transportation, you refer it to the House Committee on Transportation. There are different committees. So if the bill borders on 2 or 3 different subject matters, the 3 or 2 committees will now have joint committee. So let's assume it is a bill on security and agriculture, maybe because of header farmer clashes. So you are going to have a joint committee of House Committee on Agriculture and House Committee. But the lead subject matter, the committee on that subject matter will lead. So it is at the committee level that they will look at. The term is called negative, sir. Negative, then you put ED, negative.
Okay.
Thank you, sir. So the House Committee, the 2 committees will take the bill, look at it clause by clause at the committee level. It is also at the committee level that the public hearing is done. Now, this is a democracy. The legislatures are actually performing primarily 3 functions. 1 is lawmaking, 2 is representation, 3 is oversight. Now, because it is a democracy and the law is being made for the people need to have a say in the law that is being proposed to be made for them. That is where we have public hearing. Now, at the public hearing stage, different stakeholders, relevant stakeholders in the subject matter, in the area of subject matter of the bill, will come up with memorandum, either in favor or in opposition of the bill, to say this is our position. Yes, we agree this bill should happen, or no, this should not be a law. This is the reason. And all opinions are welcome, but they are not binding. At the end of the different memorandum that has been submitted and different presentation, make necessary adjustments, and they come back to the House for the next stage. And that next stage is committee reports. Before reporting, all the members of the committee will sign their signature, write their names, and sign to conform to the report. Yes, this is what happened. This is our position. Then the chairman of the committee signs. And they come and present that committee report to the House in plenary to say, yes, we've met. This is the assignment the House gave to us. We have come to present it, because you cannot at this stage say, okay, the committee, since it is here, you people should complete whatever you are doing. If you skip it and it is that the end product is challenged in court, the court will nullify that law or act. So after the committee report, the 3rd reading takes place. Now, note the importance of the 3rd reading. At the 3rd reading, the presiding officer reads out all the clauses of the bill one by one, and the whole House will adopt the clause. Each clause is adopted separately. You do not assume that, okay, everything the committee has submitted, let's just adopt the bill. No. You go through clause 1, If there is need for amendment, it is at this point that that amendment is made. Somebody can say, instead of clause 1 to read like this, why don't we substitute this word for this word? Why don't we make it read like this? Maybe somebody say where they put will, the person can say, okay, instead of will, can we make it more binding by using shall? Can we make it mandatory? So that word will be amended from will to shall until the entire clauses is read and adopted. That is what happens at the third reading. Once that is done, a clean copy is produced, which is the next thing. And that clean copy, the process of producing the clean copy is called engrossment. That is where all the amendments are looked at again, all the cancellations, all the errors are removed, and the bill is cleaned up. We now have the adopted copy of the bill, no longer what the committee submitted, but what has been adopted by the House in plenary. Then, after this engrossment, a clean copy is produced and signed by the clerk of the House. Let's assume it is a House bill. After signing, he takes the bill to the Senate for concurrence, and that is the next stage, stage 10. Now, at concurrence, the Senate also passes the bill to agree with the House the way the House has passed it. The Senate might also bring in some amendments. There must be a committee from the Senate, the relevant committee from the House. They agree. They might say, okay, let us amend this. But two of them must come to agree them to a consensus, to a meeting of the mind of both committees from both houses. That is what happens at concurrence. That is why it is called concurrence. Agreement. The House has agreed with the Senate, or the Senate has agreed with the House regarding this bill. After that, the bill is handed to the clerk to the National Assembly, the CNA, who now takes the bill to the President for engrossment. Now, because of corruption, that's what it is, because of pardon, because of last minute insertion of things into the bill that were after the House has adopted. This is Nigerian crooked practice now. Because of that, to ensure that the bill that was adopted is what gets to the President for signing, the President of the Senate will sign each copy of the bill, of the clean copy, with a red pen to say this is the authentic bill both houses passed. Then the Speaker of the House will countersign each page of the bill with a green pen. That is the copy that will be submitted to the President by the CNA. Now, that bill is produced in triplicate at this stage because that's the provision of our Acts Authentication Act that says that every bill for presidential assent has to be produced in triplicates on a vellum paper. And yesterday I told us the significance of vellum paper. Now, vellum paper is a special kind of paper that is made of animal skin. The closest example, if you know drum sets, this drum that musicians use, band that musicians use on stage to play music, that white surface that they hit on for the foreign band, not our local drums, that's a vellum. But I don't know whether the one they use for the paper is as thick as that or lighter. But that thing does not rust. It does not decay. If you put it, after 10 years, you come and pick it up. You can dig it out from the ground. Now, that symbolizes that laws are made in perpetuity, except, of course, for laws that have a sunset clause. So the president signs the 3 copies. The process of president signing is called assent. So the president assents to the bill. Once the president's signature appears on that bill, it automatically becomes an act. Once the president signs on the bill, it automatically becomes an act. Now, 3 things are done, or 3 steps. 1, a copy of the bill is kept with the CNA, or let me put it this way. Firstly, the CJN for enrollment, another copy with the AGF for gazetting, the 3rd copy with the CNA for numbering. Now, these are all provided in the Acts Authentication Act. On how, if you pick any of our laws, check the back page, the authentication page. You will see where the clerk to the Senate sign. You will see where they do something like a table. They put the date the Senate passed the bill. They put the date the House passed the bill. They put the signature of the clerk. Then they put the date the president assented to it. They are conforming. It's not just design. They are conforming to the provisions of Acts Authentication Act. So once this is done, we now have a law in place. It is important to note that if for whatever reason there was an error, even during the engrossment, and they coupled that error and took it to the president and he signed that error becomes part of our law. And nobody, not the judge, not the executive, not the lawyer, not even the attorney general, not the CJN, not the CNA can unilaterally correct that error. In fact, the court has held that nobody can correct comma to full stop in a law except the legislature. So that error has to go through the process of amendment of that bill for it to be corrected. That means you will initiate a bill to amend that particular law or act, and the amendment bill goes through this process. Any question, please? Dr. Rima, good afternoon. Welcome, ma. I cited you.
Good afternoon, my brother.
Good afternoon. Welcome, ma.
Thank
Madam
you.
Yamen, welcome.
Honorable.
Madam Toyi, thank you for joining us again today. Welcome.
Thank you.
Okay, questions? Yes. Madam Shetak, please ask.
Yes, I'll be fast about it, given the time within which the class
Yes.
would end. The first one is, you mentioned that a bill is technical. When a bill is technical, the interpretation section will be at the beginning. So at what stage do you consider a bill technical to decide whether the interpretation section will be at the end or at the beginning? Because what might be technical to me might not be technical to another person. So in essence, every bill would be technical to someone.
Relatively. Okay, good. That's a fantastic question. Firstly, that was in relation to Lagos. Lagos has their drafting style. That's what the business rules and business committee does. For the National Assembly, their drafting style is that the interpretation session is at the end. For Lagos State, their interpretation session is at the beginning. Now, what makes a bill technical? Let's look at the petroleum sector. If you are drafting a bill in the petroleum sector, or even tax bill, there are terminologies you will use that is not everyday language. Do you get it? So, you will need to put the definition of those technical words, the jargon of that sector. If you are drafting a bill to regulate the medical practice, they have their jargon and what it means to them. Even our own law practice, we have our legal jargon and what it means to us as lawyers. So these are technical words, different from maybe when you are drafting maybe agriculture bill. I'm not saying that there are no agricultural jargons. Do you understand me?
My thoughts exactly.
Beautiful. So that is it. I don't know if I've answered your question.
You managed to, but you've not answered it because agricultural terms might be technical to me as well, using your example. So
yes, that's why I said. That is why I said. Firstly, what you need to understand is in-house style. Why do we have interpretation session? Interpretation is for words to have, for readers to have knowledge of the words as used in this bill and their meaning. Then Lagos State says, this our definition session. We will put it first. That's our style. So if you draft a bill that has interpretation session at the end, Lagos State, that bill will not pass because it is not their in-house style. But that bill will pass at the National Assembly. Is it clear?
Yes, it is. Thank you.
You're welcome. Mr. Oscar, please, your hand is up. Quickly. You're welcome. We can't hear you. Please, sir, can you repeat yourself? Yes. We have another diagram there. We have another diagram there. So we will look at that tomorrow and consider the lawmaking process in Lesotho. Yes. Solomon, please.
Okay. Thank you so much, Prof. We are grateful for the time that you have spent for us. I just want to ask on the issue of the gazetting procedure. You had said that the Attorney General, it will be taken to the Attorney General
for gazetting.
So what is the procedure and what the effects of gazetting? What if it's not gazetted?
I like that question. What is the effect of gazetting? Very intelligent question. The effect of gazetting is that this is the authentic copy. The government has its own printer. Do you get? Now, anybody can put anything online. Yesterday I said that ordinarily, the bills and acts that these people hawk, copies that they hawk on this thing, on hold up or by the roadside, is supposed to be gazetted. Okay, let me cite an example. This year, I bought our new Supreme Court rules. They have two versions. They have a hard copy. They are selling it for 5,000. Then they have another one that incorporates other bills. So I ordered for it. My supplier sent me the hard copy. And for me to maximize my money, I wanted the one that has other laws, other acts attached to it, not just the Supreme Court rules. And I called him. I said, why did you not give me the other one? and he made a statement, which is this example I'm citing. He said the hard copy is the one that was produced by the Supreme Court themselves. These other ones, marketers coupled it, business people coupled it, and now added other laws to it so that it can sell. And he said there might be mistake in those ones, I don't know. But what I gave you, the hard copy that is containing the law alone, is from Supreme Court. So what gazetting does is it shows that this is the authentic law that was passed by the federal government, by the National Assembly, the one that was assented to by the president. People can, in the course of copying, in the course of even typing, somebody might want to pick a copy and retype and now begin to mass produce, to sell. In the course of doing that, the person will erroneously type one word wrongly. If you bought it, you have bought the wrong copy. So you cannot rely on that. That's the essence of gazetting, sir. To say this is the authentic copy.
Thank you so much, sir.
You're welcome. Any other question, please?
Yes, Mr. Ebenezer, my hand is up. So,
okay, I thought it was the first one.
No. So you mentioned that there is a case where it was held that no correction can be done on a legislation except it undergoes review or amendment by the House. Can we have that citation?
I will, after the class, I will just put it on the floor.
Okay,
on
great.
the WhatsApp group. Then Prof posted, I have that law, I have those legislative drafting law report, legislative law reports. Please look at them. If possible, buy them. Now, there are materials that Prof has been posting on the platform. Please download the ones you can download and read. These materials, we are getting them free of charge. We have easy access to them. When you will value this material is if you find yourself doing any research on legislative drafting and you don't even know where, or if you have seen anybody doing any research on legislative and don't even know where to start or how to access materials. So, I am going to snap a copy of this law report, legislative law reports of Nigeria from 1962 to 2010 or thereabout. I have the complete set. It's not cheap, but if you are playing along this line, I will encourage you to buy them. All the cases are there. All the decided cases so far, apart from those that came after that, they are all there. Please, I will encourage you to get those, particularly Madam Shetak. This is your line of duty. So I will encourage you to pick it up. All the cases you need are there. But after the class, I will provide the one I made reference to. Thank you very much. Madam Shetak, contact Prof.
Okay, I'll do that. Thank you.
You're welcome. Any other question? Any other contribution? So tomorrow we will look at the lawmaking process in the Kingdom of Lesotho, so that we even compare and contrast whether they are the same. Thank you very much. Do have a wonderful day in the absence of any question or suggestion. Thank you everyone and goodbye.
Goodbye, sir. Thank you so much for your time.
Goodbye. Thank you.
Goodbye. Thank you.